Now we will be going with the GDPR. So when we are talking about the GDPR, I think most of you will be already familiar with this whole scenario that the replacement of the 1995 was the GDPR, General Data Protection Regulation, and these are here are some of the its primary principle that is over there. So applicability has to do with the processing of the personal data in the context of the activity and establishment of a controller or processor in the European Union or in the European Union Economic Area. Lawful means your processing of personal data is only allowed if the data subject has freely given specified information in a simple plain language, and you're telling lawfulness means you're telling that user plain in simple language that what you are going to collect, what you have, all that thing, and in you are just going to go ahead and specify them and get the consent from the data subject over there, right? Now the accountability obligation. So accountability obligation, it has to do with the creating numerous obligations for companies. As an example, GDPR, it requires companies to keep the record of their data processing activity. Certain categories of processing is going to require a prior privacy impact assessment as well. Okay, so these things you have to do. Then data subjects have some rights. They have they have the right to information regarding the processing of their data. They have a right to object to certain use of their personal data, to have their data corrected, or if you want to erase that data, that also can be there, or to be compensated for some damage suffered as a result of some unlawful processing of the data itself. If someone has unlawfully accessed the data, you can just go ahead and simply kind of ask for the some redeeming from the some of the or what I would say uh, redeem some of the you can claim for the your compensation over there, right? If your data got leaked or anything, so you have that right as well. And one of the stronger point of GDPR is its cross border data transfer restrictions over there. Now when we are talking about these things, this strong rule that the transfer of the personal data outside EU and EEA to a country that does not offer a similar range of protection of personal data or privacy rights is strictly forbidden. You cannot transfer the data outside EU region unless they provide the same kind of the privacy data protection over there. Now, breaches of the security, if that happen in any organization, so they suffer a security breach with the data subjects data. So what they have to do, there are the reporting requirements. They are risk based, and there are different requirements for reporting the breach to a supervisory authority and to be affected data subject. And breach must be reported within 72 hours of the company becoming aware about it. So there will be different rules for the different kind of the data risk that they are having, and authority plus data subject both has the right to know what has been leaked. Then discrepancy among your member state is a way of looking at the state having different jurisdictional and national law in order to have more common way of actually addressing the violation. So every state has their own kind of a law on to the top of this. If someone is breaking these things, so they have the right that how they want to address those violations. There are standard plus each individual nation holds the right what additional kind of a thing they want to do over here. And then sanctions are related to the violation of that GDPR, where company is exposed to significant penalty. So it can be the greater of either your 4% of the your their global turnover and revenue, gross income, or up to 20 million euros. So whatever they like, right? Either 20 million euros or whatever is greater, either 20 million euros or 4% of their global turnover and revenue, gross income, right? That is the bit of the sanctions that what we can think about. Now, similar to not similar, but a different one, there is the NIS directive, which entered into the force on the August 2016, requiring each EU and EEA member state to implement the directive into the national legislation by May 2018. So the NIS directive, they establish a framework to enable network and information system to resist at a given level of confidence action that compromise availability, authenticity, and even your integrity. Okay, so if there is any compromising availability, authenticity, integrity, and confidentiality. Now, country level services are maintained in order to protect the network against the attack. Okay. Now, the member state national law must impose network and information security requirement on the operator of their essential services. This would be the entities that provide service essential for maintenance of your critical societal and economic activity. Included in this would be the way of managing through the incident and through significant disruption itself. Now, member state national law will also have to require the digital service provider to identify and take appropriate, proportionate technical and organization measure to manage risk proposed by the security of the network information. So, these are the directives that each country have to create their laws on, and these some of the points that I have talked about, like for the network security, these things should be focused on those particular laws over there itself. So this is something that is one of the part. Now let's just move to the one of the region which I think most of us are familiar with, which is the America, right? Let's consider the American region as well. So when we are talking about the Central and South America, in Central and South America, they have adopted the data protection law at the very rapid pace. So each of these laws include a security requirement and place on the data custodian the burden of ensuring the protection and security of the personal data, whatever the data is, wherever the data is located, and especially when transferring it to the third party. For example, if I talk about the Argentina, Chile, Colombia, Mexico, Peru, Uruguay, they have passed a protection law, which is inspired by your mainly I would say your European directive, that 9546 EC, and may include some of the reference to the APEC privacy network over there. And then the federal data protection law of Mexico, it includes security breach disclosure provision, and to do many other countries in the central and the south countries as well, South American countries as well. Okay, then there is the United States privacy law, and in United States, we have highly sectoral approach to manage the privacy law. So there is the local level. First of all, you may have city laws, municipality laws that specify the code of conduct and behavior that must be maintained in order to protect your PIIs. Then there is a state level. So you could have state law that that through the state administrative capability are enforced, so that anyone practicing consumption or processing in that state for cloud, they have to follow these laws. For example, in California, if you will be familiar, that what they have passed, I think they have that Attorney General, their office, California Attorney General office, they have submitted that, in on, I think around 1st June of 2020, when we were on the lockdown. So during that time, they have proposed the regulation, okay, package under the CCPA, California Consumer Privacy Act. And many of the element of CCPA might actually remind you of the GDPR with the robust data privacy right and control over personal information that data subject can maintain. So it will be very much similar to that. So in the each state, they will be having different state laws. CCPA is, I think, in last 2 years, it is gaining some quite popularity over there, because, and if you'll be reading about them, it is pretty much similar or almost remind you of the GDPR. We focus very highly on the privacy and protection. Then when we talk about the federal, there will be a lot of federal laws. For instance, if you have heard about the GLBA, Graham-Leach-Bley Act, right, that help you to regulate your financial data on individual. You have HIPAA, which we keep talk about. We have seen few points about the HIPAA already. Okay, we have the HIPAA. We have the COPPA Act as well, which is Children Online Privacy Protection Act of 1988, which limit the amount of information that can be collected on children 13 years old and younger. And I remember when I was taking the exam of CCSE, there was this question. Okay, so you should have understand through the local, state, and federal laws, the laws that apply to your practice over there. Then there is going to be the, your European Union United States Privacy Shield. So in working with the European Union, United States has the privacy shield. Okay, like I was talking about that in the between US and EU, there is a kind of a agreement. So with the working with the European Union, United States has the privacy shield, and it was adopted around, I think, in 2016, okay, by the European Commission, and the privacy framework become operational around on the same time, I think, okay, on the 2016 itself. So I think around a month or so was after acceptation, it become, work as in the work as well, operational as well. And framework, the framework, what it does, it protects the fundamental right of anyone in the European Union whose personal data is transferred to the United States for commercial purpose. Now, it allows for the free transfer of data to the companies that are certified in the US under the Privacy Shield. This provides effective protection for individual citizens of your European unions, and there is annual joint review by European Union and United States to monitor, and to correct any of the applicability on the privacy shield. So they try to improve them over the time, that yes, this thing should not be left in hurry and something like that as well. Okay, so this is the something that what we are talking about.